Hello to all the viewers at Sovereign Empowerment. Obviously, I don't need an introduction, being a good friend and compatriot of Gavin's. I'm here to personally introduce a wonderful man that I've been following. This man is the real deal. Not only a constitutional law expert of 30 plus years, a registered paralegal, and a very, very successful litigant with proven results, and is currently embroiled in more success at present, helping a young man enforce his civil rights against a corrupt London police force. And with great success, I believe a settlement offer has been put out there. And obviously, I don't know much more about that. We can find out in due course. He's also the leader of his own political party and society. So without further ado, I'm going to introduce Graham Moore, and I'm going to enjoy this as much as the viewers. So I'm going to shut the fuck up now. And nice to speak with you again, Graham. God bless you.
And you, and God bless you. So really, there's a number of things. I just want to make sure I've really come on here to explain to people, what we do. And obviously the conversation last night, before I go on, it's not just about me. There's many other people just like me. I have a great team of people. But having a conversation with you last night was fantastic, because I realised that you was exactly the same as what we do, right? So what I mean by that is you're using the real law, not all this psyop stuff that's going on in the background. And I don't mean disrespect to anyone who started following that. People need to know that there is a real law of the land. And it isn't what's being presented by a lot of people on YouTube. Your channel should have millions of followers, right? It doesn't, because it's being suppressed. And today, even though I know I can say what I like to you off camera, because you're on YouTube, there are certain things I would refrain from. And the reason for that is because this isn't on Rumble. Rumble is the only channel that won't take you down, and you just say it as it is. So just to give you a quick indication of some of the things I've done, and I'm not going to disparage anyone in name or person or channel, but all of these so-called common law experts and all sorts of things in the background, let me just say this to you. Have you ever been in a court of law? Have you ever read a real law book? Have you ever took the British government to the European Court of Human Rights and won an injunction against them personally? And that was in relation to a little girl that they murdered, right? So we won that injunction. All of the British barristers, solicitors, all said there's nothing more you can do. And we did it. And we extended her life at least by a week until they lifted the injunction. What I'm trying to say to people is, get in there in a court of law and prove to me that you know what you're talking about. And until you do that, you're nonsense, right? That's all you got to ask them. And people like the gentleman I'm talking to now, Daniel, have actually been in the court. I've had circuit judges in Leeds reverse, in other words, quash people's convictions because of what I've written in case statements. In fact, I've had the circuit judge pull up the prosecution and say to the prosecution, you was wrong. I'm putting a complaint in, not only about you, but the originating magistrates, right? And that circuit judge did all that. So what I'm trying to say is there's a group of people that tell you the real law, and this channel is one of them, right? And it's about putting your money where your mouth is, getting in there, being polite to the court, right? Because the rule of law is ours. It belongs to us, right? You don't go into a court and say to a judge, read me your oath, right? Listen, they wouldn't be sitting on the bench unless they'd taken the oath, right? It's called the oath system, and it's the oath systems that binds our society together. So again, there's lots of things that we've done. too many to list, too many cases that we've won. I'm getting some feedback off my earphones, I think. But the main thing is to remember, I'm not a solicitor, right? So I want people to understand that I am not a solicitor. I'm not a barrister, but I am what's known, and you can go and research this, as a common lawyer, right? Every Englishman is a common lawyer, and people need to understand that. So the biggest thing to remember is I'm not a solicitor. So when people come up and ask me, I'm like, do three main things. And the three main things are constitutional law, which is all about your inalienable rights. No one can take them. They're God-given rights. The second is I am about people's disability rights, right? So what I'm saying about disability and pensioners and the people who can't fight back anymore, right? So we look at that as where we can, bearing in mind I'm not funded. And the third thing, and this is going to be probably important for this particular episode, is universal jurisdiction. People don't understand what it is, and it is powerful. It's just as powerful as the English Constitution, and it's where we can hold the British government to account for their abuses towards the people. What is universal jurisdiction? And let me just say that universal jurisdiction is very, very important, right? There's something called the United Nations Convention Against Torture. It was ratified by the British many moons ago, prior to 1988. And in ratification, they also incorporated it into domestic law. So you'll often hear people saying, just an example, if you bring up a United Nations law, our government will say yes, but we haven't incorporated it into English law. Well, UNCAT they did. So the Criminal Justice Act 1988, Section 134, incorporated torture as a criminal offence. And this case with Charlie Staples, let me make sure I'm clear. Section 135 states that you must get authority by the governor, and not the governor, the Attorney General and the Solicitor General. So when he was attacked by the police, people may not know that Charlie was going to what we call the petitions at Trafalgar Square, coming up there to meet me, and there was many of us, hundreds of us. There was actually thousands at Trafalgar Square. He was attacked by the riot squad. He's of slight frame, and basically they nearly killed him. They put him in a prone position, which is face down on the floor, handcuffed in, proceeded to use once he was handcuffed and in the prone position, proceeded to use what's known as pain restraint techniques when there was no need for it. Absolutely no need for it. He offered no violence. It was a wrongful arrest. We already proved that in the magistrates. And then the police officer, particularly a police sergeant, stated that he had been assaulted, assaulting an emergency worker. And if I went into the detail of that, you'll see that the whole thing is being abused. It's an abuse of the system, an abuse of process. So we proceeded. It was the first part of the case, which was to do with lockdowns, was thrown out. This is a Westminster Magistrates Court, the worst court in the land, right? If you want me to tell you the story about my appearance there, I will, but you'll have to remind me because most people think that's hilarious, right? But the situation is that and it was a judge. He'd read the case statement, and so did the prosecution, and they said no case to answer. That means the initial arrest was unlawful. There was no reason to arrest him. That was it. So that case had gone, and then and this is really important for everyone to understand. Everyone listening to this needs to understand this, right? The assault of emergency worker is triable either way. What does that mean? It means you can elect for a jury. So Charles Staples elected for a jury, and it went to Isleworth's Magistrates Court, where he represented himself. Just make sure everyone understands that. Didn't use a barrister, didn't use a solicitor. What he did use was a number of key points from me, including getting on the phone to me. The judge actually demanded that I be there, and I told Charlie to tell the judge he's got no right to demand anything off me. Full stop. Right. And the reason why I didn't want to be there, because then the judge would have made the excuse that you are represented or you've got assistance. And I knew that they would then try and stitch him up. So he done it completely on his own. Trust me, he's got some bottle, right? And he did. It was a 4-day trial where the evidence was presented, and we've got a 30-minute, this is where citizen journalists come in, right? Because the whole event was recorded, everything that happened, everything that was said, right? And it shows a complete abuse of police powers. That's the first thing. The second, and that was obviously put to the jury, it was all shown to the jury. The second thing is that 3 of the 4 officers that are now listed in the civil case, their cameras was working. One of their cameras showed another police sergeant, whilst Charlie Staples was in the prone position, face down on the floor, being abused by the police quite seriously. He couldn't breathe, blocked his airwaves, right? Now that's a human rights abuse. It's a criminal offence, right? They blocked his airwaves. That's on their video, right? Here's the kicker, people. The principal tortfeasor, the person who initiated it and initiated the arrest, his camera wasn't working. Right? So on the other videos, it shows the principal tortfeasor, whilst Charles is face down on the floor in the prone position, smashing his head on the floor 4 times, right? All of this was shown to the jury. The judge had seen it, so the police sergeant comes up for questioning. Obviously, it's awkward doing cross-examination when you represent yourself, right? So the judge asked some questions. So the judge said to the police sergeant, after seeing that, "Can I ask you a question? Why is it that you smashed his head on the floor 4 times?" And the police sergeant said to the judge, don't forget the jury's listening to this, "It was for his own safety, Your Honour."
My God.
Let me tell you something now. And I've been told this, I didn't witness it myself, it looked like the judge could have punched him, right? The arrogance of the man was unbelievable, right? The jury started laughing at the police officer. So without going through the whole trial, the jury went out and they come back. Oh, no, sorry, let me just get to, this is really important. Anyone should know this. Under English law, you cannot appeal a not guilty verdict. So the state cannot appeal a not guilty verdict. And it was one of the reasons why double jeopardy was so important. It's been so now they've relinquished on that, and you can now get tried twice, which is against English law. I won't go into that in detail, but I'm telling you now, they can't appeal a not guilty verdict. Let me just say this, Jill. The judge put to the jury unlawful violence, and in his directions, and there was legal argument with the CPS. By the way, I wrote out a full list of authorities and what to say, and I said to Charlie, if you can't say it, hand it to the judge. It's really important. So he handed it to the judge, and then there was legal argument. They adjourned, and Charlie rang me up, and he said, "I don't know what was on that note," to the judge. He said, "But it has caused a massive argument between the CPS and the judge." He said, and the judge is like, "Whoa!" like on it, right? So I went, okay, right. I said, that's the intention, is the judge needs to understand exactly what we're saying, right? So basically, the judge then said to the CPS, I am putting torture to the jury, right? As an explanation of unlawful violence, right?
Mm.
State violence. And it's really important because police officers, and again, just for everyone watching this, police officers are not public servants. Get that out of your head, right? We are not a republic. We are a constitutional monarchy. They are crown servants. And it's really important that people get that. So many of these other channels say, public servant, public servant. They're not public servants. They are crown servants. And it's important under English law and ancient usage rights, right? So again, the judge put to the jury, after legal argument, the CPS said, we don't want you putting that to the jury. We don't want you saying that, right? And there's a reason why I'm telling you this story, because it's important. The judge put to the jury that an example of unlawful violence is torture, right? And he basically said to the jury, if you believe that Charlie Staples has been tortured, you must return a not guilty verdict, right? The jury come back with your unanimous, not guilty, right? So I had Charlie literally in tears, right? Because he went through all the pain of this trial. During the process, his mum died, who was jabbed, right? And the state of abused him no end. And I'm just going to say this to people listening. There is a certain other channel out there. I'm not going to say who they are, but one of their members or one of their presenters used to work for GCHQ. If you don't know who I'm talking about, that's fair enough, right? They've never mentioned this. They've never mentioned the Criminal Justice Act, Section 134, torture. All they ever do is literally support the British state. And it is England that is under attack. And it is the common law that's under attack. It's our constitution that is under attack by Marxists, communists, and another group of people. And they've never mentioned it, right? Yet their channel, every time my channels go up, they get taken down. Why? Because I tell people the truth. I tell people about the real law. And it's one of the reasons why your channel won't be elevated. And there's a lot of things that I would say on here, and I can't, because your channel will get taken down, right?
Brian, you've made a really important distinction. Sorry to interrupt. It's most people, 90% of people, certainly within the law movement, they don't understand the distinction, the difference between English and British. And that is a huge thing for people to really get their heads around.
Absolutely. And I want to make sure everyone understands this, right? I'm an Englishman. I'm not British, right? And when people say to me, no, well, we're all British. No, we're not, right? And England is distinct. It is a nation. So let me just briefly say what that is before we continue with the story. And it is important for people to understand this, right? Britain is an island. It contains two countries, England and Scotland, both different jurisdictions. Scotland is Roman law. England is the common law. It contains a principality called Wales, right? And for any Welsh listening to me now, screaming, we're a country, not a principality. In 1536, you was absorbed into, right, England. I am not suggesting you're not a country. You can return to nationhood. I would love to see it. Absolutely love to see it. I completely support you, right? If you become a socialist communist nation, expect the biggest border you've ever seen in your life between England and Wales. And it is for the people of Wales to sort that out. Not for me. It's not my culture. It's not my language. It's not my nation. It's for the people of Wales to sort that out. and I believe they will, right? Same goes for Scotland, right? So getting back to the difference between British and English, the Acts of Union of 1706, 1707 did not create a country. It created a political union. And the reason it was actually brought into effect with no referendum, by the way, because the English and the Scots people actually objected to it. It was the ruling class that did it, was because, and here's a little bit of history that many people don't know. You've got something called the, is it the Darien Gap or the Darien Gap? It's basically Panama. It's in South America. The point is, Scotland launched into a bid to colonize that area. The English was already partially in control. The Dutch was in partial control. It's a very important strategic area, right? And this was in the late 1600s. And what happened was they bankrupted themselves, right? And this is factual, by the way. People can go and read about it. And in doing so, Scotland was bankrupt, and they literally had to come on board with the English to save themselves from bankruptcy. And the English kept saying to them, like, don't try and colonize that area. And the people who fought the hardest against the Scots was, guess who? The indigenous population of that area. And the indigenous population beat them twice. They couldn't beat them. So remember where it come from. So the Acts of Union, 1706, 1707, and by the way, there's a very simple way that Scotland can come out of the Union. That's why I know they don't want to come out of the Union, because it's very simple in law to do it. You don't need a referendum. Just to make sure everyone's aware of this, the Acts of Union, so the British haven't got a constitution. They've never had a constitution, ever, right? The Acts of Union was basically there to bring some of the lords from Scotland and the MPs from Scotland into the English Parliament, and then they created what's known as the British Parliament, right? But it didn't. It was a political union. It's not. It's nothing whatsoever to do. The actual nationalities come along a little bit later, and I'll give you an example of that. The British Nationality Act 1947 and the British Nationality Act 1981, which erased English, Welsh, Scottish, and Irish, right? The last person to do that was a guy called Joseph Stalin, right?
Oh.
In the USSR, because he was the commissar of identity. So what you're actually seeing is going against the indigenous rights, and again from the UN, because we are an indigenous population. England is and again, England is 1,067 years old. So getting back to the Acts of Union, what it did was protected the constitution of Scotland, and it protected the constitution of England, right? And once people, this has all been taken out of the education system, the curriculum, etc. So remember that British is a political union. It is not a country, right? It doesn't represent a country. It protects the two individual constitutions. And for those who say we haven't got a written constitution, we have got a written constitution. We've got what's technically known as a common law constitution, which incorporates a lot of other things, including the charters. So the Magna Carta, for example, 1215, I can show you where it said you can't repeal it, right? And the reason why it can't be repealed by a parliament is because it was outside of the jurisdiction of parliament. So they can't repeal it. They can repeal some parts, but only if it doesn't contain certain phrases. A.V. Dicey changed his mind in saying that Parliament is sovereign, but you never hear that from the legal profession. He actually wrote another book that said that. There was a case in Scotland, I'd have to look it up to tell you which one it was. It was in 1953, And there was an argument against Queen Elizabeth II being called Queen Elizabeth II. So the Scots took it to court under constitutional law and said she can't be called Queen Elizabeth II because we already had that as our own monarchy, right? In that case, they admitted that there were certain laws, constitutional laws, that cannot be repealed. And if they've got phrases in it, you can't, certain phrases, and there's many phrases. For example, forever. If it says in a statute that's passed, and especially if it's passed by a convention parliament, right? So again, I could go into the history of the convention parliament, and then people would be going, "Oh my God, really?" So why don't we know all this? Well, you're supposed to be taught it in school, and here's a kicker. The Acts of Union tells you that these rights should be communicated to the people. That's where, and I'm just going to say this, Joe, where America gets its "We the People" documentation, right? So you've got this little leaflet here, right, that we give out, and it basically is a "We the People." It tells people, right, what your rights are, what the constitutional statutes are, not all of them, but most of them. And we've got something like 15 constitutional statutes and charters. There's a lot more. Most people don't even mention the Charter of the Forest, for example, which is still part of our law. It can't be repealed, and it is to protect us. But you've also got, for example, the Charter of Liberties. You've got the Magna Carta. When you go through all the history and you understand the Constitution, all of that is still in place to protect us. So the difference between English and British is vast. One is a citizenry created by the state, and the reason they did it is because then they could take your rights away. If they turn around to you and say you're British, not English, right, which is what they're doing, then as the British have no rights. The English have the rights, the Scots have the rights, the Welsh have the rights, the Irish have the rights, but the British don't have any rights, right? That's what they're doing. And people don't understand that this is so nefarious in the background, right? So hopefully, let me just say one other thing. The Acts of Settlement, 1701, apart from saying that the laws of England are your birthright, and that's everyone, right? And they are your birthright. You have the right to stand up and say, "I claim these rights. I am an Englishman," right? The point being, the original statute said, listen, no one born of foreign parents, basically, this is me paraphrasing, but just so people understand, can be in any position of power in England. So if you haven't got English parents, right, you can't be an MP, you can't be a lord, you can't be a judge, you can't be a barrister, you can't be a police constable, you can't be any of these things. Can you start to see why they want to eradicate English law? Because if you've got Englishmen running England, right, all of a sudden a lot of your problems start to go away, right? And that's why they need to eradicate it. And I want to say this, and then I'll carry on with the story, right? People need to understand the ultimate social justice system is the common law of England. It is God's law, right? And our constitution is God's law. When these people who run this country, England, actually believed in Christ and God, right? And they bestowed upon us God-given rights. All they done was put it in law and said, listen, we didn't give you these rights, God gave you these rights. And it's up to you as Christians to defend it, right? And that's all we're doing in the background, is defending them rights. But people must understand that the Act of Settlement is just as important as the English Bill of Rights, the Declaration of Rights, and the Declaration of Reasons. I can go into a load more, but getting back with this story, if I can sort of get to this position, because I'm sure the audience would be saying, we want to be get to the story, right? So we then launch civil action against the police, and there's some crucial elements that people need to understand, and it will cover off, and people will start to understand this and think it's so we launched an action against the police, but before we did that, we launched the action and proceeded with a private prosecution against 4 police officers directly under the Criminal Justice Act 1988, Section 134 for torture. There are 2 elements of that, and that is the actual violence used in the assault and the arrest, unlawful arrest, which has already now been proven. And secondly, the psychological torture of lying, abusive process, which if people want to ask me about this, because there's a funny story about abusive process, right?
It's a common law offence. That's my understanding, is it not?
Torture.
No, the abusive process.
Right. So let get me back on this story.
Sorry.
So one of the things, I mean, I'd have to bring up the actual pleadings, but so malicious prosecution, assault and battery, there's about several different talks that we've brought up. And by the way, I mean, I've got talk books here that thick, right? So we also put in there, because the police officer lied, right? Just plainly lied, right? So forget the perjury side of it. He lied to the CPS. And it's one way that we've gotten by the short and curlies, right? He obviously lied to the CPS, and we've got proof from the CPS in effect, because they changed the charge, right, from assaulting an emergency worker to attempted assault, right? So, and there's some other variations of that, which I won't go into, but let me just say, so we've put abusive processes as a tool. The police solicitors and barristers come back to us and said, there's no such thing. I said, really? I said, so why is it the Law Gazette has just reported on a case, a tool, which hasn't been used for 180 years?
Oh, brilliant.
And they've just paid out 14 million to the person. Do you want to tell me the reason for that? If an abusive process doesn't exist, right, as a tool, why is it that the council in the Midlands have just paid out £14 million to a person where their CEO was in a relationship with someone else, right, and stitched up the governor of a pub and put him in prison for 2 years, right? All a bunch of lies, right?
Wow.
Why is it they paid out on abusive and the key thing here between malicious prosecution and abusive process as tools is you don't have to prove malice. You just have to prove they've lied to the CPS. For whatever reason they did it, we're not interested. We're just telling you they've lied. Right?
And that's the element.
Yeah.
That's the element to prove. That's fantastic. So just that one element.
There are some other elements. I'd have to look up the actual talk, because talks have got certain elements that you have to prove, right? Which we're going through with this case at the moment. There's a lot of work involved. But the point being, when they started coming back with these things, and then so we've gone through this process of private prosecution. Now, Section 135, in my view, unlawfully says you must get the permission of the Governor General or not the Governor General, the Attorney General and the Solicitor General. So we've put in all of the bits and pieces. They've come away and said, no, we're not giving you permission. So therefore, they've taken, the Crown have stopped you privately prosecuting someone. In other words, another Crown servant. That's why it's really important you understand the difference between a public servant and a Crown servant. So the Crown is blocking you. They haven't told the international community that they've got a veto, right, on prosecuting. So again, we've done lots of freedom of information requests. We then took it to the High Court for judicial review. They totally without merited it, right? So again, judges are crown servants. We then appealed it, again, totally without merit. They're crown servants. So that's been blocked. So the criminal aspect of this case of torture has been blocked by the Crown, because they will not allow the world to know that they're British police officers. And let me just tell everyone this while I'm on the subject. 1,888 English and Welsh people have died in police custody since 1990.
That is criminal.
No one has ever been put in a court for torture. I can name at least 5 cases where there was clear evidence that it was torture, right? And people listening to this should understand how serious this is, right? Because any one of them 1,888 people who died, many during restraint, many not resisting arrest, right? Just like Charlie, who thought he was dying, right? Just to make sure, I'm going to tell you this now. Most people would be. So we put freedom of information requests in to the Metropolitan Police, to the CPS, to the IOPC, and to the Crown, right? We said, how many applications in total have been brought in, have been put in to prosecute the police for torture since 1988? Do you know what they come back with? 0.
0, my God.
Right. We are the only people that have used that law and smashed it on them. Now they don't like it, because now it's started to be recorded. And let me make sure I'm clear on this, right? I'll get angry about this. All you solicitors out there, all you barristers out there, all you so-called human rights experts, right? You've seriously let down the public, right? Because that law exists and you have never, ever used it, right? Because you're cowards, because your oath, your everything about what you do, you are sucking on the teat of the British establishment, and you will carry on. And you will carry on letting people like me, you, everyone else there, die in police custody as long as you're paying your mortgage. That's not what the English law's about, right? So do I get angry about it? I do. Because all these people are pumping money into all these things. Inquest have never, ever taken this up. All barristers and KCs and all these people never, ever brought it up. And they're taking money off you, they're getting money off the taxpayer. And people like me and our group are not funded, right? We're struggling for money. We're always struggling for money, yet we stand for the people. And the difference is, once that happened, now here's the key kicker, right? This is where it ties, and now I'm going to say something, and I hope it don't, I'm going to have to tell it as part of the story. It's a true story, right? So this part of the case, the prosecution, is going over to Texas under universal jurisdiction. We've got to raise the money for it, but it's going under universal jurisdiction. What is universal jurisdiction? It's when the people have been oppressed and suppressed and tortured by the state, and the state will not allow those prosecutions, right? So you can then take it to another jurisdiction. That's why it's called universal jurisdiction. Just to let you know, people, I'm an expert in universal jurisdiction, and I'm going to wipe the floor with the British, right? Let me just tell you this. We've already had a conference in Texas with legal professionals. And what I said to them was, these 4 police officers, and bearing in mind the other case, the civil case also includes the police commissioner. People need to understand that I said it is the Crown that is standing in the way of this prosecution. So when I spoke to the people in Texas, I said, is there any limitations that who we can put on the indictment? And they said, no. I said, so if we was to put King Charles III as the monarch, and these are his servants, can we do that and prosecute King Charles III? And they said, since 1776, oh yes, you can. Right?
Can I ask, is that a form of vicarious liability?
It is, and I'll get into that. I'll tell you what, that's a really good question, right? For people, and for two reasons: for the civil argument, because that's one of the things that we beat them in the High Court with. What you've just said, they put an argument, and I went, and then showed the judge the paperwork, and the judge said, "Woo!" Right? So let me. So we will remind me about that.
Okay.
So it is, but this isn't. There's two different. You're talking about a different legal scheme. We're talking about this is a criminal case, right? So therefore, the vicarious liability don't come into it. He is part of. They're doing what they're doing, if you like, under a conspiracy under his name, right? Because they're crown servants. That therefore he can go on the indictment in the United States of America under universal jurisdiction. So we intend to bring that case, right? And I'm telling you now, we got to fund it, right? So and it's not made. Everything has been laid out, and they're certainly going to get one right on the chin, right? And they're going to stop what they're doing, right? So again, people don't realise the power of the law, especially universal jurisdiction. So tell you another story very quickly, right? I don't know. This is the bit that can get a bit iffy because it's actually true, but I don't like it being said. Royal Dutch Shell, the board of Royal Dutch Shell, given indication or directed the president of Nigeria back in the 90s, I think it was, it might have been the 80s. I'd have to go back and look at the case details. But they directed the president of Nigeria to torture and murder some eco activists who were trying to defend their village against the oil company. And the president basically tortured them and killed them, right? At the behest of Royal Dutch Shell. One of the board members of Royal Dutch Shell was a guy called Sir Vince Cable.
Oh.
Right? The family in Nigeria tried to bring a case in the British courts against the board and Sir Vince Cable. Their case was kicked out of court. Right? They protected the establishment. They protected Sir Vince Cable. They brought the case in New York under universal jurisdiction. And then they made a massive payout to the family, out of court settlement, and said, we apologise. Right?
Wow.
So people don't know. And that story, you can go and research it. And I've researched the law on it, by the way, is called Parliament's Dirty Secret.
Right? Brilliant. And I'm sure they've got many.
So that, and there are many, right? So all I'm trying to tell you, if you think it's BS that I'm telling you, people don't know. The mainstream media certainly won't tell you because it's all controlled. Ofcom is the equivalent of Glavlit, and Glavlit was the people who controlled the communications in the USSR. We are now under what I call the British Soviet system, right? So people often say, do you think there's going to be a civil war? And I always say to them, we're in it. We're in a civil war. The communists have taken over England, and there's other people out there leading people in the wrong direction. So just to make sure people understand this, I am a strategist. I've studied strategy for a long time, Sun Tzu, etc. I've worked for corporations. I am technically a system engineer. So I look at systems and I put things in place and I see things in a different way to most people. Anyone speaks to anyone with an engineering mind, you will know that when they look at something and something's broke, there is a different way of looking at it to the average person, right? Again, so let's get back to the full story on that. So that part of it is going over to the USA, and that's the criminal aspect. It's nothing to do at all. It's under universal jurisdiction. People need to understand that we then proceeded with the civil court. So it goes into court, and the other side turned around and said, "You've listed these officers. By the way, one." And this is a civil action. We want their name, not just their number, right? So in which we got and that was the police sergeant, I believe, who blocked his airwaves, right? They didn't want to give his name. So getting back onto what happened, one of the things that they said was, this goes back to your vicarious liability. They turned around and said, and they used corporate law, right? They turned around and said, no. These individual officers are not they're not liable. They're liable under the police commissioner, right? So what I did was showed them the Police Federation president's statement in their documentation, where he said individual police officers under ancient laws and customs are individually liable for their actions, not the police constable. And the police constable can also be liable. But it also said in that document that a police officer, a police constable, it's very important to understand that there's a difference between officer and constable, and it's true, right? We have police constables, and it doesn't matter what rank they are. So whether it's a police constable, police sergeant, police inspector, superintendent. There's a lovely video of me talking to a chief superintendent, where I referred to him as a constable, and he said to me, I'm a chief superintendent. And I said, you only take one oath, and that oath is as a police constable. And to members of the public, you are a police constable. We're not interested in your internal ranking system, right? And there was a police woman sergeant burst out laughing and walked away, right? But afterward, not afterwards, I think it was the next week, she said to me, no, you're right. Absolutely right.
Brilliant.
The internal ranking system is nothing to do with a member of public, right? We are all police constables. Even the chief of police is a police constable. That is the oath they take. And there's an important thing about perjuring an oath, right? So cut a long story short, it goes up, and the judge has listened, and they was fighting tooth and nail, right? So in other words, they wanted to take the individual officers off because we've got all the video evidence of what they did, and just leave the police commissioner on there. And then the judge took 30 minutes to come back. She was superb, by the way. Young, black judge, right? And the reason that I'm saying she's black is because all these people, I'm not a racist, right? She was more for our English constitution than any frigging judge I've ever seen, right?
Brilliant.
And then she turned around and said, I agree. And by the way, that the authority you've used, which is under corporate vicarious liability, doesn't count. And here it is. She said, they are Crown servants. They don't work for a corporation. And the police commissioner is not head of a corporation of police. He is responsible to the Crown. And they are all Crown servants. And therefore, you cannot use that argument, right? So we won, basically. And the barrister left the court like he hated it. So the next, I mean, we just had another hearing at the High Court, and I did say to Charlie, they're going to do everything they can to kick it out of the High Court. They want it in the County Court. They want to, and there's various reasons for doing that. Some of the stuff we've put in there, so in the pleadings itself, it talks about the torture, and it shows it. And we've said we want you to create a tort of torture, and it's one of the reasons why people should take to the streets passively, no violence, but we should do what Gandhi did. We need constitutional militias, and we need to organise and set it all up. Right? I've said this for years, and the real law, not all this BS that we got in the background. So, cut a long story short, we said we want a jury, and the opposition said no. I said, well, it's our right. They kept saying no. So they create, and I will get into this in more detail. They created the CPR rules as administrative law to stop you getting to the common law, right? If people understand what they've done, and so they've made all these silly little rules and regulations. Some people call it legalese, and they've done that to stop you getting to common law, right? Because the common law and the Constitution is extremely powerful, very powerful, right? And the basis of it is under the CPR rules and under legislation of the civil procedure, and I can't remember exactly what the law is, but I know what it is, but I'd have to bring it back up again. So I put an application in, but for you to apply for a jury, you must it's your right, but you must apply for the jury within 28 days of the defence statement being submitted, right? So on the second day, we submitted our full application with all the precedents listed of why we need a jury, right? And stating it is a right, it is not a privilege, right?
Is that ancient usage and rights?
Yeah, it does cover ancient usage rights, but there's been many precedents set by judges in High Court that have said if you bring a civil action, and especially against so false imprisonment, assault and battery, anything where the state is attacked you, you can't leave it to a judge. It must be dealt with by an independent body, which is a jury, right? So I listed all these things. I mean, I'll send you the application. You can read through it and you'll go, wow, right?
I'd love to read it. Love to.
Yeah, so we had to have this. I mean, we had a directions hearing on Monday, but part of that was this, that they said they was opposing, right? So just to give you an example of this, people will laugh and think this is funny. So the last time this happened, we won a big chunk of the case. That's another thing that the judge did, right? They put in their costs, and it was about £7,000 something, and said that Charlie had to pay it, right? Again, they're trying to push you out the courts by costing you a lot of money. Bearing in mind he's just a plumber, right? Not just a plumber, he's a plumber, right? And then because we won this big chunk, she said, so you've got no cut. And I said, well, I haven't been charging a fee to assist. I said, even though it's the English Constitution Society, I want to tell you the good bit in a minute, right? Because they got steam coming out of their ears after this one, right? So the judge turned around and said, well, I'll tell you what I'm going to do. I'm going to discount your fees to cover the part that they've won, right? Now, not many judges, High Court judges, would do that, right? And she went, bing, 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 that's the figure. So we've come out of the court and we said, like, we've got to pay £4,000 or whatever it is. And as soon as I said it live on air, within 20 minutes, one benefactor said, there's the money. Bang.
Wow.
Right. And we went, bang, paid it. And I was like, and there's a reason why that is really good. I won't go into detail because I don't want to give them any ideas if they're watching this show, right? But the secondary element of it, I forgot what line I was on now. What was I talking about with the so we was getting into what they was trying to do.
Well, were they trying to bankrupt him, or just sort of make?
No, that's what they do, and people don't realise this is how important this is. If you take an action against someone, and they make an offer, so they've made a settlement offer. I can't. So originally they tried to fob him off with £1,000, right?
What?
Which
for
is
all that?
well, that's standard. That's what they do, because most muggy people out there will just take it and go down the pub, right?
Bloody hell.
that people don't realise, right? But if they make an award or a settlement offer, and you refuse it, but let's say we're getting into the region of, I don't know, £100,000, right? If they made that offer, so I'm going to ask you, I'll ask this audience, it's an absolute right, right? In other words, not qualifiable. It's an absolute right not to be tortured by the state, right? How much is that right worth to you? I'm asking you as the jury, you, the people watching, tell me how much that right's worth. That's the difference between now in England and America. If you put that question to an American jury, you'd get 1 billion, right? So what they do is they make an offer where they think, well, a jury will award this or a jury will award that, right? Bearing in mind they don't know what our arguments are, or they do, but not fully in a skeleton argument. So the basis of it is, if you was offered £100,000, and if you went to trial, and the jury awarded you 90,000, right? So their settlement offer was 10,000 more. You have to pay all of the legal costs of the other side, and that's going to bankrupt you, right? You'll end up with nothing. And that's what they've done, and it's an outrageous liberty, right? But that's what they do, and it's a way of coercing you to take the offer, right?
Yeah, yeah, it's lawfare, isn't it?
In a big way. People don't realise that's why lots of people don't take on defamation cases, even though they've been defamed. Now, in the old days, fairly obviously, right? I don't know if people know where defamation laws come from. The reason why they got defamation laws is because prior to defamation laws, if we insulted each other, I'd say to you, I'll see that you on Sunday morning at 6 a.m. We'll take 10 paces, turn and fire, right? And you get really, don't forget, reputations are worth a lot of money,
Yeah,
right?
yeah,
It's the only thing that you've got, right? So turn and fire, and it meant that good people was dying. So what they actually said was, well, I'll tell you what, let's create a tort. And therefore they created the tort of defamation, right? So it could be going heard, and that way you can take the person's assets. And to some people, that's more spiteful than dying, right? If you take everything that they've got. I could go through loads of history where, and that's the good thing about the common law jurisdiction, that as society moves through, we have changed the law or put laws in place, but they are generally always there to protect you and protect the public. They're never there to protect the state, right? It shouldn't be used like that. But now, under administrative law, that is what's happening. So basically, they'll do anything to protect the state, right? Including kill people, right? So people need to understand all of that side of it. So now the case is progressing in the London County Court. The problem is that county court is in London. You're up against the Metropolitan Police. They're Crown servants. The judge is going to be a Crown servant. They don't care about us. They're not interested. I could name many cases which should have been charged with torture, right? So it again comes back to the English Bill of Rights, right? It's a pretended law, because if you've never charged it and there's evidence of it, that you've ratified it and brought it into domestic law, but no one has ever made an application, no CPS have ever pushed it through, it's a pretended law. And again, all these barristers out there are just BS, right? They're not doing it. So people should be ashamed of the legal profession and what they're doing, because they're letting you down in a big way. And the only people standing up are like me, yourself. You've won cases, I've won cases. You know, there's many people you can talk to about me, and you know, I will assist any way I can, but we don't get paid for it, so it becomes very difficult. And when you're up against the state, in every way, It's very dangerous. And I'm just going to say this. I mean, how can I don't want to get your channel banned, but a certain nurse who's been labelled a serial baby killer, right? They had raw sewage running through the wall, right? There are so many things wrong with that case. It's
Yeah,
unbelievable.
totally agree. And it's actually, I think that's sort of filtering now even into the disgraceful, disgusting sort of legacy corporate media are actually taking note now that there's a lot of disparities in that case.
Yeah. And again, I was talking about that. One of the first people going bang, bang, bang. I'm not saying she's innocent, right? Even though I believe she is, right? I'm not saying she's innocent. I'm not saying she's guilty. I'm saying that what they presented in that court, and then they blame the jury, right? Then they blame the jury. I'm going to give you another example of something here. Most people would be gobsmacked at this. There was it's a bit off-piste, but it does fit to what we're trying to talk to. So I want people to understand, if you're listening to me, there is a big difference between administrative law and the common law, right? And it's the common law and our constitution that's under attack, right? For various reasons, and they're doing it in different ways, but it's the common law that's under attack. England is the beating heart of the United States of America. America is under attack. Texas in particular, because in 1836, it adopted the English common law and the Constitution of England in its entirety, right? They have got the same culture as England. They've just got different accents, right? If you go out there, I'll tell you what, it is absolutely, they are the most beautiful people you've ever met in your life, right? Let me tell you something. You touch them on their rights, they are fierce, right? And that's the way it should be, right? They are beautiful, beautiful, beautiful people. Let me just make sure I'm clear on this. Administrative law, in effect, is Roman law. It comes from Rome, right? The Romans were, although they wasn't called this, the original communists, right? They had a two-tier system, them and us, right? And then you had a lower class, which was basically slaves, right? The people who developed the jury system were the Greeks, right? In Greece, Greeks, they did, and again, I can show you stuff where you go, wow, a completely different culture. Look at the Greek culture, look at the statues, look at what they developed. It was superb. They had the greatest thinkers, the freedom of expression, of ideas, of everything, right? So the Romans was about crushing dissent. They regard, this is the bit that people probably won't like, Britain as Britannia and a province of Rome, right? There are groups of people that still believe that, and we're still under attack by them, right? And I could go into detail and say who they are and tell you all the details of it. But the real story is this. Administrative law is what they now describe as Napoleonic law, right? What is administrative law? They write down all of the things that you're allowed to do, right? And if it's not on that list, it's illegal. Common law is the complete opposite. This one line is forbidden, but you can do anything else, right? Different way of thinking about it completely. It's the Greek way of thinking about it, right? So what you're saying is this is strictly forbidden, but you can do anything else, right? And if there's any variation or issues with it, bring it to a court, and a common law judge will look at it. We used to have something called the Court of Common Pleas, right? Which has been absorbed into the King's Bench, right? So the basis of it is administrative law is a different legal system, and it has been imposed upon the English illegally. Common law pleading. That's it, yeah. So again, I mean, I've got loads of different books here. Old books. Always read the old books. Right?
Yes.
The old books will tell you the truth before all this stuff come in where we're being majorly oppressed and suppressed, right? And we are living in a British Soviet system. right? And the British is the original union. They use unions as a stepping stone, right? So the British Union, then in 1860, without going into detail, they caused the Civil War. The southern states were about liberty and freedom, didn't want anything to do with central government, right? They're individual states, leave us alone. Don't tread on me. And then it crossed over to the USSR. There's a reason for that, and why it happened. And the British were largely responsible for the revolution. Not the English, the Scots, the Welsh, or the Irish, the British regime, right? The British establishment, the ruling elites, whatever you want to describe them as. So, and then they created the European Union, right? Which is communist in nature, not Nazi. The WEF is communist. It's actually run by the Fabian Society. So when people understand everything, and there's so much I could pack into it, we'll end up doing a 6-hour interview. But the basis of it is that they've laid upon us administrative law that really shouldn't exist in this country. We're a common law jurisdiction. They didn't ask the people. It's unlawful, and they removed from the education system the common law, the constitution, so they could apply administrative law and start to enforce it. And that basically is where we're at now, right? So people like Tommy Robinson, I mean, I wrote out I don't know him. I wrote out full when he got arrested. There was a couple of things that happened when he got arrested in Cambridge, and he attempted to sue the police for harassment. Within a few hours of reading what he was doing, I said, he's got no chance. This is an exercise in getting money off people, right? Because it only happened once. In harassment, it's got to happen more than twice, right? So for someone like me, I just looked at it and said, this is BS, right? You talk to the average person out there, he wouldn't do that to us. I said, I'm telling you, in law, this is simple. It is not harassment. It's not happened more than twice. How can you say it's harassment, right? So, and then there was a secondary element to it as well. The other case where he got arrested and he uses the English flag, which I think is disgusting, because he's vilifying England, right? And then he got arrested. I wrote out a full defence and I sent it. He put it on, not to him directly. I sent it to someone else who sent it to him. He put the full defence up on his Twitter, right? And then he deleted the tweet. He pulled down the tweet, right? So I'm like, why would he do that? Next thing you know, hands out, right? Getting loads of money in, gets a King's Counsel to represent him. And it turns out that the full defence that I put in, the King's Counsel was used, right? So I'm saying, so why didn't he just put it in as a case stated and get it on record in the magistrates? Oh, that's an important thing.
As a litigant in person, so he wouldn't have had to have employed anybody.
He wouldn't have had to employ anyone.
No, it's ridiculous. Well, it just shows you, doesn't it?
Well, it shows you. I mean, again, I'm not in this for the money. We're the people with a responsibility of holding the flame of freedom and liberty up, right? And it's our job to pass that flame, eternal flame of freedom and liberty, to the next generation. And we're the generation that's failing. And I just think to myself, I'm not going to fail. I'll do my best every day to see if we can awaken people to what the real laws of England are. And the biggest part of that is, and I know there's many people listening to this, they just, because they don't understand it, and it's simple. You need to void, not repeal, void the Acts of Union. You need to take out the rot, get rid of it, go back to our English laws and push everyone out, and push all this system back to where it was. And it would take about 18 months, but we would be absolutely rocking as a country, and everyone would be happy, everyone would be free. And that's what the common law. So remember, the common law majorly is no loss, no harm, no injury, no fraud, right? And again, there's so much that people could understand. And you're supposed to be taught all this in school. But they removed it from the curriculum. They removed it from the bar exams in the early 1970s. Why did they do that? Because they illegally took us in to the European Union, and it was against the English Bill of Rights. And they knew that. It was treason.
He was actually Sir Edward Heath was advised that by his lawyers. And that's why they buried the foreign Commonwealth document, didn't they, for 30 plus years? Right? They always wait for these nefarious characters to die off first, don't they, before they disclose?
Yeah, they do. I mean, there are other things about. There's a number of things with Heath. There's a number of things with. I mean, many of these people.
Oh yes, yeah. They've got rather nefarious social aspects, psychopathic traits, and sexual deviancy.
Yeah, and again, if people only knew the truth, the real truth. But again, our system is corrupt to the core. The only real way of taking it back is avoid the acts of union. Forget that. I mean, British and Britishness is Soviet in nature. You need to go back to the real England, and it can be done. And again, I just want to make sure everyone understands this, right? The British in particular, have vilified the English and make constant references to the English being racist. In our constitution, there is absolutely no reference anywhere to race. There is about religion, and there's a reason for that. But there's no reference to race whatsoever. I'll just make sure people understand one simple aspect. When I ask people, and I have to do when I do speeches, who freed the slaves? Was it the English or the British? And everyone goes, it was the British. And I say, no, it wasn't. It was the English, right? So Stuart versus Somerset, 1762. It's one case. There were many others. And basically, the slaves used to leave the colonies, the British colonies, and aim for England, not Scotland, England, where they knew they'd be free. Because the laws of England, the common law of England, said you cannot be a slave in England. And there are many reasons for it. And it dates all the way back, believe it or not, to Kentish law. But Wilberforce was on our side. What I mean by that is he was anti-slavery. But for 20 consecutive years, he tried to put through Parliament, a British Parliament, the Abolition Act, right? And for 20 consecutive years, the British Parliament said no, right? In other words, they wanted to carry on with slavery, right? And it was already unlawful under English law, common law, right? And it was being enforced, and more blacks was making their way to England because they was free, right? So the person who was behind all that was a guy called Granville Sharp from Durham, who happened to be working class. And he financed that, and he financed the barrister. Now, just to make sure everyone's aware, and some of this is quite shocking, right? Prior to that case, Lord Mansfield, who was the Chief Justice, and there was other judges there that listened to the case, had opined that slavery was lawful, right? Before the case, they had opined that slavery was lawful because there was money in it, right? The Attorney General and the Secretary General at the time had opined that slavery was lawful. They're British, they're not English, right? This is the bit that normally gets people. Sir William Blackstone had opined that slavery was lawful, right? Oh. When I read that, I was like, oh, right? And I've got a whole big book on it. If I showed you the book, right, it's Granville Sharp's memoirs, right? Quite an expensive book, fantastic. And there's a full archive on all this information, right? Which none of these people read, right? And bear in mind, he was white working class, right? He was actually a tailor by trade, right? Cut long story short, right? When it gets to the case, it took 3 terms, and the judge keep ringing the plaintiff saying, "I think you need to drop this case. I think you need to drop this case." Right? And the bloke said, "No, I'm not doing it." He said, "Well, you're not going to like my judgment." And when he came out with a judgment, that was a judgment, and I'm paraphrasing because I ain't got it in front of me, where he didn't say it. The barrister said this for Somerset. He said, "Free the black, because English air is too pure for any slave to breathe."
Brilliant.
And that is a statement that has, rung through the ages. So that was in 1762. There was others before that. Just to make sure everyone's aware, it was the English that freed the slaves. The British wanted to carry on, and I hate it when I talk about this, right? And Wilberforce managed the one before he finally got the Abolition Act through, and they put a law through that made it unprofitable for the ships to transport slaves, right? So and he done it he tricked Parliament, right? In them days, that was difficult. In now, it's easy, right? Because they're all thick, right? But in them days, it was difficult to trick Parliament, but he tricked them, right? And they passed this bill that made it unprofitable. So the next time he put the Abolition Act through, it passed through Parliament. And that's when the British forces, you can't do this and all that, and they went out. So just to make sure everyone's aware, it was the English that stopped slaves, right? The second thing I will say to you is, there are groups of people out there called ethno-nationalists, right? And I'll listen to anyone, and I understand their frustrations. I understand they can see what's going on with England, and England is being destroyed, and I get all that, right? There is an indigenous population of English, and we are white. You should be proud of being white. You should be proud of your indigenous English roots and what we gave to the world, including the English language. And just to make sure you understand, just that there, you see that where it says the English? Do you know what that is? It's a bottle of whiskey and an English distiller, right? That's how the box comes. There's a bottle of whiskey in there. An English distiller has just won the global award for the best single malt whiskey in the world. We beat the Scots, the Irish, the Welsh, the Americans, the lot, right? We are one of the best engineering nations in the world, right? We have invented most of what the world uses, including the internet, right? Just to make sure, be proud of England, be proud of being white, and be proud that we stopped slavery, right? I won't go into the history of slavery. It'd be a long show, but people would love to hear it, right? Let me just say this to you, right? There are people in this country that are black and brown. They are culturally English. They are Christians. And once they want to be part of the English tribe, I've got no issues with that whatsoever. What I don't want to see is this cultural BS. I believe we should be a non-secular nation. We go back to being a Christian nation, and we follow the word of Jesus Christ. Don't listen to these people in the pulpits. They're all corrupt. They're as corrupt as the barristers, the solicitors. Otherwise, they would have been standing up against for the torture law. They haven't done it. They are all letting us down. So I understand the nationalism and why they say it and what they're doing and their frustrations, right? But there is a whole set of laws. It's called indigenous rights. And England is regarded as an indigenous nation with an indigenous population. And we have the absolute right to rise up and protect our nation. Passively at first, but our constitution and our ancient usage rights says if someone attacks us, we have the right to self-defense. And even in, and again, I can't say too much because we're on YouTube, against any biological weapon that is being stuck into people's arms, and people have been told lies, it's safe and effective. Let me just make sure I say this, and any questions you've got for me, I'll answer. Let me just make sure I say this to you. People do need to understand, with reference to what happened there, our laws say you cannot be coerced, right, in any way. If you do, that's unlawful. All of that was thrown out the window by the state and the mainstream media, right? There were remedies, medical remedies that could have been used and weren't, and it was because they was off patent. And people need to understand that a biological weapon has been launched against you, right? And I can't believe how many people that was originally at the stand in the parks, and I used to go around giving speeches. I stood up for people. We actually wrote an in-depth letter that was sent to schools, etc. All common law. We was actually part of the group that stopped the schools from delivering biological weapon to children. So we've had many successes. Just remember who you are. They've tried to erase it, and Britishness is a psyop. The people who told you that biological weapon was safe and effective are the same people that told you you are British. Remember that. So if you've got any questions.
Do you know what, Graham? I think you've been incredible, very informative. And I think what I'd like to do, because we're going to have a lot of questions, certainly from our loyal viewers. So if you'd like to wrap this up, and if I could lawfully coerce you back on maybe next week, coerce you with your consent.
Yeah.
If I could have you back next week, it'd be a great pleasure, because you're a wealth of knowledge. We got so much more we could go through, and I absolutely assure you we're going to have so many questions from the viewers. You've covered certainly a few topics there very comprehensively, but I'd love to have you back next week at your convenience, and I know the viewers would love to see you again. So.
Yeah, no problem. I mean, again, it's a bit awkward. You can't say certain things on YouTube, but I have got a channel where I'm live every night, 8 p.m. I've done it for years and years. They banned me from Facebook. They banned me from YouTube. They banned me from Twitter again, believe it or not. The only real place for free speech is Rumble. There are other places, Gab, etc., where I've got accounts, but I don't really use them. I've got to start using them. But there's one particular one where I'm live, the full English show. And the reason I can't say it is because if I say it, they will probably ban this episode, because YouTube, the search engines have literally taken me out, right? So, and it's because I tell the truth. All these other accounts. So I do want to emphasize to this audience as well, this channel, and one of the reasons I agreed to come on it is because I had a very long conversation with Daniel. They actually operate the real law, right? And they actually go into court. They're respectful. They write the right pleadings. They go through the law. They've studied the real law. These other people that are on YouTube are being promoted and getting massive subscribers. YouTube is as crooked as what Twitter was, right? It's full of bots. It's full of wrong uns. It's full of idiots, the same as Facebook. I mean, when I was on Facebook, some of my videos got hundreds of thousands of views. When I was on YouTube, one of my videos got 1.5 million views. And that's basically where they asked me a question about Sadiq Khan. And I said he's the most dangerous thing to hit London since the Blitz, right?
Which is true.
And then we went through his career, which was all taking money from the public. In other words, he'd never had a real job. And I said he's nothing but a ponce. And then and this was live on the TV channel, right? And they basically, and then I got loads of text messages coming through to me. And then one woman said to me, when you called him a ponce live on air, she said, I spat my tea out. I couldn't believe you said that. And I said, well, he is. Do you know what I mean? He's sucking at the tea of the British establishment, and he's a Fabian. And don't forget, we arrested him under the common law for subverting the English constitution. So when, we do things the right way, and there's lots of things. I mean, I never told you the story about when I got arrested outside Buckingham Palace. Some people have seen that video. And again, when it went to court, I mean, I was petitioning a Manchester to the Queen outside. There was about 300 people there. They brought in horses against us, right? And there was disabled people there. The horse knocked over a disabled woman, right? So there's loads of Americans and tourists all looking and saying, what's going on there? And when he actually arrested me and put me in the back of a police van, there's a whole story to this, by the way. But when they did, I blew a whistle, because people don't realise that the English used to blow a horn. Then it went to blowing a whistle, and that's where whistle blowing comes from, right? So I blew a whistle. I was carted off to the police station. There are some funny bits to this, which I won't go into, it's too long. But the essence of it is, when it got into Westminster Magistrates, the worst magistrates court in the whole country, it went in front of the judge, and the judge said to me, what do you rely on your defence, Mr. Moore? And I held up a copy of the English Bill of Rights as authority and the Coronation Oath Act as an authority. He said, is this going to be a constitutional argument? I said, yes, sir, it is. So it was me representing myself, right? So the CPS stood up. There was 30 police officers that was part of the arrest, right? So the judge said, okay, to the CPS, he said, have you got the video evidence? And they said, listen to this. So the CPS stood up and said, no, all of the police officers' cameras were switched off, Your Honour, right? So he said, oh, right. So she sat back down, and he said, have you got any police statements? She stood up, she said, no, there's no police statements, Your Honour.
Oh, my word.
So he said, so what are you going to do? And she said, we offer no evidence, Your Honour. So he looked at me and he said, Mr. Moore, how much does it cost you and your witnesses to come to court? And there was about 50 people in the gallery, right? So I said, 350 quid. So he said, right. He said, you're free to go, and I'm telling the CPS to pay your costs of £350. And then he looked at her and he said, and I want you to pay it today, right? And the reason why that happened, there's a bit more to this. So he said, you're free to leave, right? And then the whole of the gallery erupted, clapping and cheering, right? All had Magna Carta shirts on. We all had English Bill of Rights shirts on, all sorts of stuff, right? All lovely people, right? Only nice people follow me, right? And he shouted out to the public gallery, this is not a pantomime, right? Like that. One of them, or I know who it was, right? Shouted out, oh, yes, it is, like that. And then the judge started laughing, right? And then he just got up and walked out. Everyone stood up and we went down a pub. But the whole point of this is, the English Bill of Rights states it's your right to petition, and any commitments used against you is illegal, right? So they're not allowed to arrest you for petitioning. And petitioning in the 1688 dictionary means making a demand of your superiors. So if you're petitioning, and petitioning can cover being on the streets, it comes from your petition rights. It was incorporated into the English Bill of Rights because they was arresting people that spoke out against the system. That's why the communists don't like us, because we're reintroducing all this as law. It's real law. And then all I did was proved that they couldn't arrest you for petitioning the monarch. And 2 weeks before, this is what made the Americans laugh. 2 weeks before, I had sent a registered recorded delivery which I showed in court, to Buckingham Palace that was signed for, telling them that I would be petitioning on that day, verbally petitioning, right? So I'm saying, I've told them 2 weeks in advance what I'm doing.
You followed procedure, protocol, didn't you?
Oh, listen, I went beyond thing. But when I got put in the police van, I was shouting out, constitutional rights, that's what we're standing up for. And there was loads of Americans going, yeah, brother, yeah, the Constitution, right? So, people, you should make learning fun, and you shouldn't be beaten or abused for standing up for your constitutional rights, right? They're your inalienable rights. I read law, and I've read law for 30 years, right? I rarely get involved with cases unless they're strategic, and they're really important, and that's why the state comes down on me, and whoever I'm represented, because they know. I mean, I've lost one case, and that was only because the judge was crooked. All right, and the problem is, nearly all the judges now are crooked. None of them are on our side.
They're political activists, aren't they?
They are political activists, and that's not the way. So we have a separation of powers. That's another conversation to have, and it can go into Ashby versus White 1703, where it was reconfirmed. We have a separation of powers. That's where David Starkey did a recent video, and he was at a conference, and he got it so wrong. There's a difference between a historian and a legal historian, right? Totally different, two different things. It's a shame. I like David Starkey. I think his communication skills are absolutely excellent. His knowledge on the law and England, etc., is fantastic. But he should not be giving his opinions on the separation of powers when he doesn't know what he's talking about. There is a separation of powers, and we should be demanding it back.
I agree. Here. Here. Well, do you want to wrap this one up? And
do you find the legal system overwhelming and wish you had the knowledge and skill sets to control judges, persuade attorneys, and win your case? Well, look no further. Sovereign Empowerment is proud to announce our partnership with Dr. Frederick Graves so that we can bring you the Jurisdictionary Law course, How to Win in Court, your ultimate resource for mastering the courtroom. Unlock powerful case-winning strategies as you learn to control judges like never before. This comprehensive course eliminates guesswork and empowers you to navigate the legal landscape with absolute confidence. With step-by-step instructions, flowcharts, and outlines, you'll have all the tools you need to persuade and control judges in any case or court. Learn from a seasoned attorney with over 40 years of winning experience, who has distilled his expertise into this comprehensive program. Access everything you need in one single package, including sample forms, video seminars, audio clips, and in-depth case-winning classes. Learn at your own pace, anytime, anywhere. Our 24/7 online access allows you to tailor your learning experience to fit your schedule. Access the course on your smartphone, tablet, or computer and become a legal master whenever and wherever you want. Benefit from a suite of powerful tools, including a free online legal research tool, a legal dictionary with common sense definitions, and an exclusive Q&A forum to connect with fellow students and obtain expert guidance. Good people have suffered too long at the hands of power because they just didn't know how to fight back. Now, in a matter of just a few days, you can acquire the tools and knowledge that takes law students years to achieve. Can't afford a lawyer? No problem. With the Jurisdictionary Law course, you'll gain the skills to win your case without expensive legal representation. Alternatively, equip your own legal consult with the tools and tactics to fight effectively on your behalf. Level the playing field and secure your victory. No matter what court, civil or criminal, conquer any courtroom challenge with ease. This step-by-step guidance ensures a quick and straightforward learning experience, empowering you to navigate the legal system with bulletproof confidence. As a testament to your newfound legal expertise, you'll have the opportunity to complete a final exam and receive an honorary law degree upon successful completion of the course. Showcase your achievement and establish yourself as a force to be reckoned with in the legal arena. Dr. Graves believes everyone deserves access to legal knowledge. That's why we offer the Jurisdictionary Law course at an unbeatable price. For less than the cost of a 1-hour legal consultation, you'll gain unlimited access to this complete program for up to 2 2 full years. Take control of your legal battles without breaking the bank. How to Win in Court has become the most trusted law course worldwide since 1997. Don't miss out on this exclusive opportunity to gain the upper hand in the courtroom. Enroll in the official jurisdictionary law course today and unleash your legal power. Click the link in the description below to become legally empowered today.